Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this video. This video is an emergency broadcast from easycontinuingeducation.org, and today's broadcast interrupts our normal ongoing series. And we do that because of the importance of today's message. And today's discussion has to do with recent information that's come down from the Division of Workers' Compensation and information that's come down from sources outside the Division of Workers' Compensation that is adversely affecting QMEs in the profession. According to some estimates, over 400 QMEs have recently been denied their renewal applications by the Division of Workers' Compensation. Let me say that again. That's 400 QMEs. This represents approximately 13% of the QME base. And it appears that these QMEs span the entire spectrum of specialties and locations and geographies throughout California. So it appears to be an indiscriminate cleaning of the slate, so to speak, of QMEs. And the issue, it appears, has to do largely with DWC allegations of QME doctors overbilling through misuse of the complexity factors as are described under CCR 9795. Now, it's the DWC's contention that very few, if any, reports qualify for the ML 104 billing level. In fact, very few reports even qualify for the ML 103 billing level, and it's the position of the Division of Workers' Compensation, the DWC, that most reports qualify only for the ML 102 billing level. So what we're going to see is the average cost of the per visit evaluation QMEs produce statewide. We're going to see the average cost starting to diminish as fewer and fewer reports become accepted as ML 104s certainly, and even as ML 103s, and most reports will become pigeonholed into the ML 102 category at the lowest rate of reimbursement. So many doctors are fearing that whatever income there was to be made in doing qualified medical evaluations has basically disappeared. Now, the doctors that realize that the income has completely disappeared is the 400 doctors who have had their renewals denied by the Division of Workers' Compensation. And it seems that the basis for the denial of the QME's renewal application has to do with the Division of Workers' Compensation new interpretation, with their secret interpretation, with their unpublished interpretation, with their unacknowledged interpretation of the complexity factors that we've used for years and decades as are described under CCR 9795. And as a result of this new interpretation, this unpublished interpretation, QME reports are being downcoded to lesser and lesser expensive reports due to claims from the Division of Workers' Compensation that the reports do not qualify for the claimed complexity that the doctor is reporting in his report. So what I want to do in today's discussion with you is review some of the complexity factors underneath CCR 9795 and let you know what is known, at least to this moment in time, what is known about how the Division of Workers' Compensation is newly interpreting each of these complexity factors. And I want to give you some suggestions should you decide to continue doing this type of work, this QME type of work, I want to give you some suggestions as to how to use these complexity factors safely, so that your report does not come under scrutiny with the Division of Workers' Compensation. So let me share with you a little bit about the history of this roaring storm, or this roaring wave that's now coming into shore. There was some rumble about a year ago, maybe 15 months ago, that the Division of Workers' Compensation was reinterpreting the complexity factors, and that what we thought typically of the complexity factors and how to apply the complexity factors was no longer considered to be true based upon the DWC's new interpretation of the complexity factors. Now, it's interesting because the DWC's interpretation of the complexity factors is nowhere published. There's no document that's gone out from the Division of Workers' Compensation to each and every QME within the state. There's been no bulletin posted on the DWC's website, at least that I'm aware of. If I'm wrong, I'll stand corrected. But I could say for certain that I've not received anything, and the doctors that I consult with have not received anything. So we can only conclude that this new interpretation is unpublished. It's internal within the DWC. Now, it's been my experience in talking with QMEs of all specialties throughout the entire state that QMEs are willing to comply with regulations. They're willing to comply with whatever interpretation the Division of Workers' Compensation has to put on the complexity factors, if they were only informed of what that interpretation is and what it is that they're supposed to do. In other words, QMEs are willing to comply if they only knew what to do. But it seems that there's this new interpretation that you do not learn about until the damage has long been done. And I'll share with you some examples of doctors who have been educated about this new interpretation, the extremely hard, vicious, brutal way, in the most harshest manner possible. So it would be one thing if the DWC could publish a bulletin advising doctors of new interpretation of the complexity factors, but as yet we don't have such a document. So the purpose of today's discussion is to share with you what is known about the DWC's new interpretation, and to give you some ideas as to how to integrate that into your current procedures and protocols. Okay? So the denial of doctors' QME renewal begins ostensibly with a complaint. So when it comes time for your renewal, your file comes up down at the DWC, and if there's a complaint within the file, the complaint then sparks the DWC to conduct an investigation into you, into your reports, and into your billing practices for your reports. Now, it's not clear where these complaints come from, but it seems that the complaints can come from any of the parties involved in the case. The complaint can come from the examinee, and I have an example of one doctor whose investigation was initiated because of a complaint from the examinee. A complaint can come from the claims administrator. A complaint can come from the defense attorney. A complaint can come from the applicant attorney. So that's 4 potential parties who can issue a complaint, if these complaints even exist. But the investigation is said to have begun with a complaint. And one of the doctors who was denied a renewal application demanded to see a copy of the complaint, and it's not yet clear as to whether or not an actual complaint exists within the file or not. But if you think about it, with 4 potential parties waiting to pull the trigger on a complaint against you, meaning the examinee, the claims administrator, the defense attorney, the applicant attorney, and any one of those parties could have good reason to lodge a complaint against a qualified medical evaluator at any time. Certainly, if the claims administrator is not happy with the opinions and conclusions of the qualified medical evaluator, that could spark a complaint. If the defense attorney is not happy with the opinions or conclusions, that could spark a complaint. If the applicant attorney is not happy with the opinions or conclusions, or if the examinee is not happy with the opinions or conclusions, that could spark a complaint. And because it's impossible to please all four parties all at the same time, it's highly likely that on your very next evaluation, you could be initiating a complaint against yourself as one of these parties exercises their option to complain against you. So it begins with a complaint, and you have no idea of knowing if you have a complaint against you until it becomes time to renew your QME credential, at which time these complaints come out of archives, out of your file, and into the forefront and spark the need for an investigation within the DWC. So then what the DWC will do, apparently, according to a track record of many, many doctors, they will request for your last 10 evaluations. They will ask you to send them copies of your last 10 QME reports. And they will scour those QME reports, not so much looking for indications consistent with the complaint, but apparently looking for indications and instances of overbilling through what the DWC interprets as misuse of the complexity factors. And I have an example of one doctor in Northern California who the Division of Workers' Compensation was not convinced that a single one of his reports, that a single one of those 10 reports qualified for the billing level at which he was billing those reports. And the DWC then calculated an amount that they considered to be the overbilled amount for each of those reports. And then the DWC did several things. They demanded restitution to the insurance companies for the amount that they determined to be the overbilled amount, that is times 10 reports, 10 restitutions. And then placed the doctor on probation status for 12 months. And when you're on probation status for 12 months, the words "on probation" appear next to your name on the QME panel, which is basically your scarlet letter and kiss of death that tells examinees, that tells claims administrators, that tells attorneys on both sides to stay away from you because you are on probation. So it's a harsh penalty. Now, there's two prongs to this issue. The first prong is, are these doctors billing incorrectly and are they misusing the complexity factors? That's one issue. The second issue that's being dealt with now has to do with the DWC's rights in failing to renew the QME's credential without what is known as due process, without providing the QME an opportunity for a hearing, wherein at the hearing it could be determined whether or not the QME actually is billing incorrectly. In other words, the DWC is issuing a mandate that doctors are billing incorrectly and then denying their renewal, basically stripping them of their QME credential without so much as even a hearing or an opportunity to explain themselves. So both of these issues are being dealt with legally now as more and more doctors are banding together to sue the Division of Workers' Compensation over these issues. Now, I am not going to discuss the appropriateness of the hearing process and the legality of all that because I'm not a lawyer and I can't comment on that. What I want to talk to you today has to do with your use of the complexity factors, because that's something I can speak with authority about. So let me just say that of the doctors' reports that I've read, of the doctors who have been disciplined, it's my opinion that the DWC probably opined correctly in determining that these doctors had misused the complexity factors or had overbilled because their reports did not actually qualify for the higher billing levels under ML 104. So I agreed with the Division of Workers' Compensation, at least on the reports that I read that are involved in an ongoing lawsuit with the DWC. I agreed that those reports, let's just say the doctors poorly documented their use of complexity factors and poorly supported their use of the complexity factors and poorly supported their argument that their report fully and duly qualified as an ML 104. So the DWC was probably correct in disciplining these doctors because, in my opinion, their reports were overbilled. But another more troubling issue has to do with the DWC's new interpretation of the complexity factors, which would take all of us, any of us, each of us, by sideswipe, and would give each of us a curveball and each of us a wrench in our spokes, because these new interpretations are heretofore unpublished and heretofore not available to the general QME to be able to comply with. Okay? So let's talk about each of these complexity factors, and we'll talk about the DWC's new interpretation of these complexity factors. So first of all, I have in front of me CCR 9795, and I'm going to be reading from CCR 9795. It would be helpful for you if you also had a copy of CCR 9795 right in front of you, so that we can speak intelligibly about these ideas and these topics. First of all, in section CCR 9795, it talks about the ML 103 and ML 104 billing levels, and it tells us that in a separate section of the report, the physician shall clearly and concisely specify which of the following complexity factors were required for the evaluation, okay, which are required. Number two, and the circumstances which made these complexity factors applicable to the evaluation. So it gives us instructions that we're to do two things. We're to specify the complexity factors, and we're also to explain the circumstances which made those complexity factors applicable to the evaluation. Now, one of the complexity factors has to do with medical causation. And doctors who are getting their reports scrutinized, almost as a rule, are doing a poor job in supporting their medical causation complexity factor. In fact, many doctors simply cite the phrase and use the phrase, quote, causation was addressed, unquote, as their sole support for the use of the complexity factor related to medical causation. And nowhere in that description, causation was addressed, does the doctor cite the circumstances which made the complexity factors applicable to the evaluation. And they may say something like apportionment was addressed without citing the circumstances which made a discussion of apportionment applicable to the evaluation. So we're charged here with two tasks, and you must ensure that you comply with both of those requirements for each of the complexity factors that you hope to employ in your billing. So let's go over these complexity factors one at a time. It says one of the first complexity factor is 2 or more hours of face-to-face time by the physician with the injured worker. Now, as far as I know, and it's never happened to me, and as far as I know, none of the doctors who have had their QME renewal denied have been criticized for improperly documenting their face-to-face time, or for misstating or for exaggerating their face-to-face time. So it seems that face-to-face time is fairly protected from scrutiny. Now here's what I recommend with regards to face-to-face time, and let's agree as a group to implement this as a procedure in our very next evaluation. Now, most doctors will have the examinee sign in and sign out of the face-to-face time so that they have in the record some documentation and some support for their claim of face-to-face time. And that's a good idea. That's something that I've always done. That's something that many doctors do. That's something that I recommend, so that if at any time someone calls you on your face-to-face time, you can produce this document and show with the examinee's own signature the start time of the evaluation and the stop time of the evaluation. Now, based upon new troubles from the DWC, here's what I recommend. I recommend that we take that process or that procedure one step further. What I'm going to start doing, and what I suggest that you start doing, is that after this description of the complexity factor in a separate section at the beginning of your report, when you quote that you spent more than 2 hours of face-to-face time with the injured worker, I want you to include the following sentence. It will say the following. It'll say 2 or more hours of face-to-face time by the physician with the injured worker, period. New sentence, new idea. See enclosed examinee timesheet signed by Mrs. Jones with face-to-face start time at 9:01 a.m. and face-to-face end time at 11:14 a.m. for a total of 134 hours face-to-face time, period. And include the examinee sign-in sheet with your QME report. Now, if this examinee sign-in sheet should ever get disassembled from the QME report or separated from the QME report, then you have at least made mention within the body of your report of some support for your face-to-face time. So include the sign-in sheet and then make reference to the sign-in sheet right next to your description of the complexity factor. Okay? So that's a new idea as to how to support your claim for your extensive face-to-face time. Next complexity factor is 2 or more hours of record review by the physician. And in other videos, I've discussed the process involved with the review of records. Now, most doctors do their review of records completely wrong. And the reason they do the review of records completely wrong is because they're not familiar with the 2 labor codes and the 2 codes of regulation that govern the review of records process. So if you're going to use review of records as a complexity factor, the review of records must be done exactly according to the laws, the 2 labor codes and the 2 codes of regulation that tell us what qualifies as a compensable review of records complexity factor. So I'm going to include with this today's blog broadcast a link to the review of records videotape for you to reference as to how to properly structure and how to properly format your review of records so that it indeed qualifies as a complexity factor. Okay? Now here's where it gets a little bit interesting. The third complexity factor has to do with medical research. And the complexity factor describes 2 or more hours of medical research by the physician. Now, I'm a chiropractor. Most of my cases, or all of my cases, involve neuromusculoskeletal conditions, especially conditions of the spine. In my entire career as a qualified medical evaluator, I've never had a case that required 2 or more hours of medical research. Now, I have had cases that require medical research, but that medical research is never more than 30 minutes, 45 minutes. I don't think I've ever had a case that involved medical research entailing an hour of medical research. So my point is, depending upon the type of cases that you're getting, 2 or more hours of medical research is probably going to be a complexity factor that you'll never use. Now, I don't want to speak for all specialties, because some of the other specialties of doctors may use medical research more than we do in the neuromusculoskeletal evaluation, but indeed still 2 or more hours of medical research is quite a tall threshold. So if you use 2 or more hours of medical research as one of your complexity factors, you have to do and you have to document your medical research properly for it to qualify as a complexity factor. So it says here that an evaluator who specifies complexity factor 3, which is the medical research complexity factor, must also provide a list of citations to the sources reviewed and excerpt or include copies of the medical evidence relied upon. Now, doesn't that make sense? If you're going to charge for medical research, shouldn't you provide the parties with the benefit of that research? Shouldn't you disclose to them the sources and the citations that you referenced in conducting your research? Shouldn't you provide the parties with the conclusions of your medical research? Shouldn't the conclusions be applicable to the case that you're working on? In other words, the medical research must be related and associated with the case. And I've had doctors, and I've reviewed the reports, who cite medical research, but they're doing generic research or rehashing old boilerplated research that is not specific, is not custom, and is not applicable to the case in chief. And the opinions and conclusions of the medical research are not associated with the context and the facts of the case. And it's simply an attempt by doctors to capture medical research as a complexity factor when it actually does not apply. So the 2 or more hours of medical research is quite a tall threshold that I submit you'll probably rarely use as a complexity factor. If you do, you have to document it perfectly according to the letter of the code. And what qualifies, let's develop this a little bit more. What qualifies as medical research? Well, let me tell you what does not qualify as medical research. It does not qualify as medical research for you to review the AMA guides, okay? It does not qualify as medical research for you to review the ACOM guidelines. It does not qualify as medical research for you to research a medical condition that's within your specialty as a QME provider. We assume that you as a doctor, within the specialty of a QME provider that you are, we assume that you have full working knowledge of the condition, of conditions that are within your scope of practice. So that narrows the scope greatly of the types of issues that would require extensive or even any medical research. So I had one doctor recently who billed for 2 or more hours of medical research. This was a chiropractor, same profession as me. So I'm familiar with his case. I'm familiar with chiropractic QMEs. And he was billing for more than 2 hours of medical research, and he did not have a listing of his citations. He did not have a listing of his sources reviewed. And I asked him, where's your medical research? What qualifies as your medical research? What medical research did you do? And after going back and forth with him for a long time, he disclosed to me that his medical research was the use of additional symptom questionnaires because he had to research whether or not the patient or the examinee was possibly suffering from anxiety or was possibly suffering from depression. In other words, during the course of the evaluation, it became apparent that the examinee might have symptoms with depression or anxiety, and so the qualified medical evaluator provided a depression symptom questionnaire or an anxiety symptom questionnaire and cited that as part of his medical research because he had to research the anxiety. Okay? And in my opinion, I don't think that that's consistent with the intent of the language of the medical research complexity factor. So, as I said, to reiterate, with regards to medical research, I believe that 2 or more hours is something that you will rarely do, and so it's such a tall threshold that you will probably not use the 2 or more hours of medical research complexity factor. Okay? Now, the next complexity factor is quite interesting, and this is where the DWC is bringing in a new interpretation. And we'll talk about this one and one more, and we'll conclude for part A of this discussion, and we'll pick up with additional complexity factors on our next discussion. So complexity factor number 4 says 4 or more hours spent on any combination of 2 of the complexity factors, number 1 through 3, which again was face-to-face time, review of records, medical research. 4 or more hours spent on any 2 of the complexity factors, which shall count as 2 complexity factors. Okay? So if you're doing 2 hours of face-to-face time and you're doing 2 hours of review of records, that qualifies as 4 hours, which gives you 2 complexity factors. Then in order to qualify for an ML 103, you just need 1 additional complexity factor. To qualify for an ML 104, you would simply need 2 additional complexity factors. Okay? So nothing earth-shattering there, except that it says any complexity factor used to make this combination, in other words, this 4-hour combination, shall not also be used as the 3rd required complexity factor under ML 103. So in other words, you can't double dip with these complexity factors. So even though you may have 4 hours between face-to-face time and review of records, you can't then employ 2 hours of medical research to make up the 3rd complexity factor. The 3rd complexity factor has to come from outside these first 3 complexity factors. So there's a little twist there, but I have not seen any problems associated with violations of that provision. However, with regards to the next complexity factor, and this has to do more with the ML 104, but it also does relate to the ML 103. It says 6 or more hours spent on any combination of 3 complexity factors, 1 through 3, which is face-to-face time, review of records, medical research, which shall count as 3 complexity factors. Now, notice it says 6 or more hours spent on any combination, let me reiterate that, any combination of 3 complexity factors, which shall count as 3 complexity factors. Now, the DWC has a new interpretation of what any combination can be. So let's think of some combinations of these complexity factors. Could you spend 2 hours face-to-face, 2 hours review of records, and 2 hours of medical research? That would be 6 hours, and it qualifies as 6 or more hours spent on any combination of the 3 complexity factors. So 2, 2, 2. What if you did 3 hours, 2 hours, 1 hours? That's 6 hours. That would qualify. What if you did 2 hours, 3 hours, 1 hour? Or 4 hours, 1 hour, 1 hour? That would qualify as 6. Is it possible that you could qualify as 3 or more complexity factors if you did 5 hours face-to-face, 1 hour of review of records, that's 6 hours, but 0 hours of medical research? That is 6 hours. That is any combination of the 3. In other words, 5 hours, 1 hour, and 0 hours. That's a combination, right? 4, 2, 0, 4, 1, 1. Those are all different combinations, correct? It says any combination, but the Division of Workers' Compensation has reinterpreted this to mean that the any combination that you use among these 3 complexity factors complexity factor that I want to talk to you about is complexity factor number 6, and this is where it gets really, really interesting, and this is where most doctors have had their disputes with the Division of Workers' Compensation. The complexity factor states addressing the issue of medical causation, comma, upon written request of the party or parties requesting the report. Upon written request of the party or parties requesting the report. So in order to invoke medical causation as a complexity factor, you must have a written request to address causation from a party or the parties requesting the report. Now here's where it gets really interesting. This description of the complexity factor is new. This is a new shortened version of the complexity factor. The prior complexity factor used to be longer. It used to say exactly the same as what it just says, but it had an additional tag at the end. It used to say, addressing the issue of medical causation upon written request of the party or parties requesting the report, comma, or, comma, if a bona fide issue of medical causation is discovered in the evaluation. So who is it that discovers a bona fide issue of medical causation during the evaluation? That's something that's discovered by the QME doctor, correct? Correct? So it used to be that the doctor, the QME, could invoke causation even without a written request from the party or parties if the doctor discovered a bona fide issue of causation during the course of the evaluation. Now that last tag sentence has been removed. So in essence, the authority of the doctor to invoke causation as a complexity factor has been taken away from us. Now, the only justification for the use of causation of a complexity factor is when we have a written request from the party or parties requesting the report. Now, that doesn't seem so difficult, does it? Because most times, the cover letters that we get request some addressment of causation in one of its many faces, in one of its many ways, shapes, and forms. We receive cover letters that request that we address causation, correct? We do, right? So this shouldn't seem to be such a high hurdle to qualify for this complexity factor. But the Division of Workers' Compensation is throwing a new twist into this complexity factor by requiring doctors to do some investigation, to do some inquiry, and to use their critical thinking skills to determine, as the doctor, as the QME, if there's a disputed issue of medical causation involved in the case. So the doctor does not receive his authority to invoke medical causation as a complexity factor simply from the written requests when parties request it. No. The written requests, plural, are not enough. Now the doctor has to do some extra work to find out if the case is a denied case, if it's a delayed case, if it's, I'll give the 3 criteria to you in a minute. For the doctor to discover through investigation, through phone calls, through letter writing, if medical causation is a disputed issue in the case. In other words, the doctor can't simply follow the instructions that are given to him by the cover letter, because those cover letters are many times generic, boilerplated, templated. The doctor must then go into work mode and discover for himself if medical causation is an issue in dispute. And then, and only then, if medical causation is found to be in dispute, meaning if the claim certainly has not been accepted, right? In accepted claims, according to the DWC, medical causation is no longer in dispute because the claim has been accepted. So certainly in accepted claims, the DWC's position is that causation can never be used as a complexity factor because in an accepted claim, medical causation is no longer in dispute. Even if the claims administrator asks you for a summary or a synopsis or a new description of your opinion of the medical causation of the case. So we have no way of knowing how this is going to shake out. If this is going to, if the language of this complexity factor is going to be changed. This is completely an unpublished position of the Division of Workers' Compensation, and this provides the bulk of many of the infractions that are being levied against qualified medical evaluators is an apparent misuse of the medical causation complexity factor. And in our next session, we'll talk about how you can properly document your use of medical causation as a complexity factor when it applies. We'll talk about apportionment as a complexity factor. We'll talk about what it's going to take from here on out for any report that you ever do to qualify as an ML 104 under the new interpretation of these complexity factors. And then I want to share with you some facts from an ongoing lawsuit that's being lodged or levied against the Division of Workers' Compensation by a Southern California law firm who has been contacted by many QME doctors who have had their QME renewals denied. So the lawsuit involved in that case, I've read it. It's a matter of public record. I have a copy of it. I'll be providing a copy of it to you in our very next discussion. It reveals some very interesting insiders' insights to the operations of the Division of Workers' Compensation that I think it's critical that we understand, that will possibly help some of us, many of us, hopefully all of us, avoid similar fates as to our colleagues who have had their renewal applications denied. So in concluding today's discussion, I want to let you know that we're in a difficult environment now with our QME practice. It seems that the Division of Workers' Compensation is seeking to take any money, any reasonable money out of this endeavor as a business enterprise. In other words, they're trying to eliminate as much as possible the ML 104 billing level, and they're making the ML 104 extremely difficult to qualify as a billing level. So with most reports qualifying, at least according to the DWC, as the ML102, or in rare exception as an ML103, you can see that the reimbursement rate for these two billing levels is quite low, and reduces the doctor's hourly rate for work to an unacceptable level. It can reduce the doctor's hourly billing rate to $30 an hour, $40 an hour, $50 an hour. I mean, for an ML102 at $637.50, how many hours can you spend on that report before your hourly rate is down next to nothing? And so it seems that any profitability as to the business aspect of QMEs is basically diminishing and disappearing. And with discipline and restitutions being levied against doctors, it's possible that you could be doing QME evaluations today, or next week, or next month, that are going to be the subject of discipline at your very next renewal cycle, that you may be ordered to pay restitution upon at that time. You could be doing reports today that you're going to be ordered to pay restitution on in a year from now when your renewal becomes due. So what do you think about that? I'll let you chew on that and sit on that and think about that for a little while. So that's where we have it. We have a very difficult environment with the authoritative body, the Division of Workers' Compensation, now asking us to work for lower and lower reimbursements. And I just don't personally see how it's possible, because from my experience, to do these reports correctly, to incorporate all of the required elements, to do a reasonable activities of daily living assessment, to do an adequate exam based on the AMA guides and based on Escobedo, and to provide opinions that qualify as substantial medical evidence. All that stuff takes time, and is complex, and it's very difficult. And at the ML102 and ML103 level, doctors are simply not going to be able to do the quality of reports that are required by the system. So I don't know where this is going. I'm simply keeping you posted on what's known currently up to the minute. So this is part one of our emergency broadcast. Look forward to being back with you here very shortly as we continue in our next session, session number 2 of our emergency broadcast. So this is Dr. Barry Carpenter. Look forward to being back with you here again very shortly.